Good afternoon. This is Judge Elisa Bettis presiding over the 210th District Court civil docket. We'll call it an add-on docket. For March 7th, 2024, all matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we're streaming all matters live via YouTube for public viewing. I will recall cause number 2021 DCV 3996, Paseo del Este Municipal Utility District number 1 versus City of El Paso through the El Paso Water Utilities.
Hi, Mr. Hughes. Board. Hi, this is Joe.
May I have announcements, please?
Ryan Green on behalf of the plaintiff, Paseo del Este, MUD number 1, and with me as well is Harold Davis, Paul Terrell, and Jeff Kirschbaum.
Good afternoon, everyone. Stephen Weller on behalf of the El Paso Water Utilities Public Service Board, and also have Gunnar Sequist here and Patricia Borshaw, the EP Water's Assistant General Counsel.
Thank you, everyone. Okay, this is a continuation from our hearing yesterday. Mr. Weller, I think you had finished, but after we took a break, I'll give you a chance to restart if you feel you need to do that. If not, I'll hear from Mr. Green.
No, Your Honor, I think I had gotten through the thoughts that we intended to present to begin with. Thank you.
Okay, thank you. Mr. Green, go ahead.
Yes, thank you, Your Honor. So this is a contract action. The parties are fighting over the terms of the contract. A lot of what Your Honor heard yesterday from a defendant is about what they think, quote unquote, should be done, or what people in the industry think is the quote unquote best way to perfectly calculate cost of service in a vacuum. We also heard a lot about how different wholesale purchasers with different contracts with EP Water are being treated. That's not our case. Paseo is asking for the benefit of its bargain under its contract. And that contract is in the record, and those are the terms that we're relying on. Your Honor asked a question early on of EP Water's counsel if it was in fact intended that EP Water could just change the methodology of how peaking rates were calculated. Why didn't the contract just say that? And we agree, that's our case. If they were right that they could 18 years later start charging us the 10% surcharge, or 18 years later start calculating the peaking differently, the contract needed to say that, and it doesn't. When Your Honor asked that question, the defendant's counsel's responses, one of them is that we had acknowledged that this was just a stopgap. That's just completely false. We didn't acknowledge that. The contract says what it says. And if you'll recall, the contract was amended, Exhibit J was amended in 2007. We had started receiving service in 2005. In other words, there was individual peaking data, but the contract was not amended to say, okay, for now, system-wide, 10 years later, 15 years later, 20 years later, you'll change it. It doesn't say that. So it's just not true that we acknowledged at any point that this was just a stopgap. The other answer I heard was that there was another customer, another wholesale purchaser, where they used the stopgap approach, where they started with system-wide and then moved to individual. That's not our contract, that's their contract. And that particular wholesale purchaser doesn't have an Exhibit J like we do. Their contract doesn't say rates are going to be determined according to this set methodology. Our contract does say that. And it's our contract, not these contracts that Your Honor hasn't even seen with these terms that are supposedly identical to ours. That's just not reality. We're trying to enforce the contract that we entered into through our negotiations, 2003, amended in 2007. So let's go back to the contract real briefly. Your Honor, we heard this all yesterday, but here we are. Section 4.1. Can Your Honor see that on the screen?
Yes, sir.
Okay. And so I've highlighted the key phrases. What is this? Page 29 of the 2003 contract. The PSB agrees to use the same methodology that it used to calculate the initial PSB wholesale rates, which methodology is set forth in Exhibit J, to fix the PSB wholesale rates for the district in the future pursuant to this contract. Initial rates, future rates, all the same methodology. And by the way, there's no time period after the future. The future doesn't end after 20 years. The future is the future. Now, there is a phrase I've highlighted right after that that acknowledges there's an automatic adjustment. That phrase has to be harmonized with the sentence that comes before. And the only reasonable way to harmonize that, because you have a same methodology and you have automatic adjustments, the only way to harmonize those two provisions is that the formula stays the same, but the numbers plugged into the formula change. And the same thing is in 4.2, hammering it home. The cost of service methodology used by the PSB to establish the initial rates, establish the PSB wholesale rates as described in Exhibit J, applies to the development, future rates, development of rates for both retail and wholesale service. Again, later on in the same section, 4.2, we see that there will be annual updates, but that has to be read in harmony with, consistent with the provision that came before, which once again, same formula, adjusting and updating numbers plugged into that formula. That's how this contract was written. That's how it was intended to be construed. And remember, that's how it was construed for 18 years. And it wasn't until 2021 that all of a sudden they decided they wanted to increase our rates, that they started saying things like ours is unfair or unequal or not the way that things should be done. That would require an amendment to the contract. And then briefly, a couple other arguments I've heard. As far as I remember, we're talking unambiguous contract, plain language. At one point, council talked about, well, was there consideration? And specifically, was there consideration for these individual things? That's not how consideration works. Consideration is for the whole contract. You don't have to say, but what was the consideration for the 10% exclusion? That'd be like saying, what consideration, when I bought my house, what consideration did I pay for the chimney? No, I paid consideration for the house and I got everything that came with it. That's how it was with the contract. There's no dispute. This is a valid contract supported by consideration, and Paseo is entitled to all the benefits under that contract. There was another time deposition testimony was used to say our president said he didn't recall negotiations about the 10% surcharge. Well, in the same deposition, he said he wasn't involved in the negotiations, but regardless, 20 years ago, you don't get to change the provisions of a contract based on whether someone remembers a specific provision getting negotiated at that time period. If the provision's in there, it gets enforced. And this is, remember, an unambiguous contract. We're not bringing in evidence of what the parties subjectively intended. This is a summary judgment, unambiguous contract. I want to talk about the conservation credit. So, and I'm not going to go too long, Your Honor. I think we had a solid 2 hours yesterday.
Almost.
Almost. So I don't want to overstay my welcome on this, but I want to hit the conservation credit issue and then the law and then just wrap up because I think the contract is that clear that we really don't need to spend too much more time on it. So conservation credit, I'll go back into the contract here and specifically let's get into Exhibit J. Because the copy is cleaner on the 2003 version, I'm just going to go to that. And so this is the Exhibit J in the summary judgment record. Talked about this a lot. Here is the payment to the city. That's the 10% that's pulled out as a cost exclusion. And here is the conservation that's pulled out as a cost exclusion. Why do they need to be pulled out as a cost exclusion? It's because the total costs up top have baked into them those amounts. So those numbers on the top row, that total system O&M capital cost, those include the 10% surcharge, and they include charges to the in-city retail customers that were conservation charges. And they use that money to create an ability to get more conservation-friendly flushing toilets, those sorts of things. But the point is, Both 10% and conservation were baked into the cost that we had to pay up here, absent a cost exclusion. The parties negotiated the cost exclusions such that no, we're going to take out the 10% surcharge and we're going to take out the conservation charges. That's the conservation credit. So what Mr. Weller said, as far as we were complaining about the conservation and then we stopped complaining, here's what happened. We saw that they had stopped giving us a conservation credit. So we added that to the lawsuit, say, wait, you can't change the methodology. And then we learned in discovery what had actually happened was conservation charges were no longer being put into this top line because they were no longer charging their in-city retail people. In other words, there was no reason for credit anymore because there was nothing to credit. So that is actually an example, like we're saying, of the methodology didn't change, the numbers that plug in change. So because this number up top no longer includes any conservation charges, these numbers here on the conservation line are going to be zero. There's nothing to take out. That's just updating the numbers. But here's the key on that. And please let me know if this is not making sense, because I do want the court to understand that our interpretation of the contract is completely consistent, set formula, updated actual numbers. If the city started doing conservation charges again, let's say next year, then those amounts would get plugged into the costs. And we would be entitled to, under the formula now, the conservation credit coming back in here to pull those back out. If nothing's coming in there, we don't have to credit anything. But if something's coming in there, we get to credit it. So that's what actually happened. And so, yes, it's true that we dropped the conservation credit from our lawsuit because we learned in discovery that that was actually correct. They were just updating the numbers. They hadn't changed the methodology. Contrast that with the 10%. These numbers up here to this day, no dispute, continue to include the 10% surcharge, which is why we're entitled to, under the set methodology, to have the credit here of those amounts. The methodology stays the same, even as the numbers change. So again, Your Honor, let me know if you have any questions about any of this. There's answers to everything that was argued. The point being, of course, set methodology, update the numbers within the set methodology. Okay, the law issue, and I don't want to linger too much on this one. So this is where they're saying, well, even if Paseo's right that they're entitled to not pay the 10% surcharge, well, that would be illegal. And so therefore the court should hold that EP Water wins. That's not true. Under the statute I've referred to, 791-026, Texas Government Code 791-026, I've got it on the screen. This section prevails over limitations contained in another law. Now, you heard in defendant's argument a whole bunch about these other statutes that could potentially come into play and maybe conflict. Well, remember, we're talking about the text of a statute here, and let's look at what the contract says about the law that it's entered into. Last whereas clause in the contract. The parties desire to enter into this contract under the authority of and pursuant to the Texas Interlocal Cooperation Act, and there it is, section 79.026. That's the statute that applies, and the parties agreed that's the statute that applies. That statute allows this sort of rate setting be done by contract between wholesale water seller and wholesale water purchaser, and that's what happened here. Now, if they think that their rates charged to us are illegal, I mean, obviously we're not complaining, but if they truly think that's the case, remember, under the cases that Mr. Weller talked about, they can go to the PUC and complain about that. They can complain about rates being illegal or not equal or not uniform, but the court's job in a case for a contract under this section is to rule the contract is valid and enforceable and to construe its terms. That's what happens in a contract dispute in a judicial proceeding, and that's what we're here for. We're just asking the court to construe this contract as it's written, a set methodology with numbers that can be updated or adjusted. And by the way, this notion that the wholesale purchasers are all treated equally and uniformly, that's just not the case. You heard plenty of caveats in Mr. Weller's argument, and let me just show you the chart here of how this is all set up. Lower Valley Water District, no 10% surcharge, individual peaking factors. Fort Bliss, the opposite. Yes, 10% surcharge, but no individualized peaking. It does system-wide. Paseo, under our contract, we don't have to pay either because of Exhibit J. And yes, there are other wholesale purchasers that have to do both, but this notion that everybody's treated identically is just not correct. And one more thing I'll show, Your Honor, before I wrap up on that point. This is an exhibit in the record. This is an EP water document. It's saying what the 2021-22 rates are. And Your Honor, if you go through this, you'll see for each of the wholesale purchasers, the rates are calculated differently and are different rates. And 1.68 there, $4.05 here, $2.98 here, and all with these different lines and different things coming out. So it's just not correct in the first place that the wholesale purchasers are being treated equally and uniformly. It's because they get to contract differently. But setting that aside, again, all we're asking the court to do under our claims is to construe the contract we have, the benefit of our bargain, because a deal is a deal. And EP Water made a deal with us that Exhibit J would be the same set methodology throughout the future of the contract, and we have sued to obtain the benefit of that. And one last thing on that, I heard defendants counsel say at one point yesterday that we were making a mountain out of a molehill. And yet, as he acknowledged, there's $3 million has accumulated in these accounts. That's $3 million that they're trying to overcharge us in just 2 or 3 years alone by not following the contract, by not following the methodology that we agreed to in the contract. There's only one reasonable way to harmonize the provisions, and that is methodology stays the same, even as the numbers update and plug into them each year. Thank you, Your Honor.
Thank you, Mr. Green. Mr. Weller?
Thank you, Your Honor. I appreciate the court's time again. We simply disagree with PDE's interpretation of the contract. We agree that a deal is a deal, and we are following the contract. As we showed in our presentation yesterday, and as I can briefly go back again now, we are interpreting and harmonizing all the terms of the contract in the only way that makes sense. PDE wants to limit these the concepts. The contract says we can adjust the rate to conform to the PSP wholesale rate. PDE wants to limit that to things that were in the Exhibit J, and that's just not what the contract says. So if I can share my screen for a moment, Your Honor.
Yes, sir.
I'd appreciate it. Thank you. I don't want to spend too long on this, but this is a summary. It's not a summary. This is the language directly from all rate making sections of the contract. Anything that conceivably relates to the rates, word for word. And I just want to go back through this quickly. The first sentence, section 4.1 rates, basically, in many ways resolves the whole issue. It says that the PDE's rates, the district shall pay an amount equal to the PSP wholesale rates. So it says your rates are not going to be your own calculation. Your rates are defined herein after referred to as the PSP wholesale rates. There is nothing in this contract anywhere that intimates in any way that PDE would be able to branch off the way they're suggesting now and get their own rate model. It just does not exist. You go further down here to the sentence that they refer to so much, which is the PSP agrees, or let me go a little further, Your Honor. At the top of section 4.2, there's more description of exactly what Exhibit J is. And it says the methodology in Exhibit J is used by the PSB to establish the wholesale rates as described in Exhibit J and applies to the development of rates for both retail and wholesale service. So what that means is they're defining Exhibit J and they're saying, look, this is just the methodology that we use for all of our customers, for all of our retail and our wholesale. It's part of the methodology we use for all those folks. So it is not something that PDE individually negotiated. Then with those understandings, PDE says the PSB agrees to use the same methodology that it used to calculate the initial PSB wholesale rates, which is set forth in Exhibit J, to fix the PSB wholesale rates in the future. So we're going to continue to use that general methodology that is our PSB wholesale rate methodology. But the very next sentence says the part of the rates for water supplied under the contract, again, consisting of the PSB wholesale rates, shall be automatically adjusted as the PSB adjusts its wholesale rates. The net of all this is that we cannot indiscriminately change PDE's rates. The utility cannot just go in and willy-nilly start putting PDE by itself and charging things to PDE alone. What this means is, from the very beginning, as much as PDE does not want to acknowledge it, they signed a contract saying that their rates would be defined by the wholesale rate model used for others. And when we make adjustments to that model, which defines their rates, they go along with it. Period, end of story. And that is all we're doing. That is all the utility has done. They made a change that applied across the entire wholesale customer class. And when they make that adjustment, PDE agreed repeatedly that their rates would go along with it. What they're doing now is they're interpreting the contract in a way to say, well, now we're limited to this update process. And the result of that is that they would then be able to avoid the same things that they agreed to, which is to follow this standard rate model, which they agreed would apply to them. So we are applying the contract correctly. We are applying the agreements that the parties made. You've heard a lot of talk about, well, it was this way for 16, 17, 18 years. Okay, it was that way for all wholesale customers for all that time. And we're not really talking about what's happened before. We're talking about what's going to happen in the future. PDE's position is basically that their treatment during the first part of the contract, the first 17, 18 years out of 60 years, it's a 60-year contract, would somehow prevent other parts of the contract from operating, would prevent us from adjusting their rates along with other wholesale customers, the way that they agreed could happen. And there's just nothing in the contract that says that if we don't invoke this ability to make an adjustment to the overall wholesale rate model, that we would somehow lose it. You know, there's nothing in the contract that says the utility would waive that ability. The utility has a pretty well set wholesale rate model, and they don't make adjustments like the 10%. They don't make those kinds of adjustments very often. But the fact that it didn't happen during the initial, third of this contract, of this 60-year contract, does not mean that it goes away. There's just nothing in the contract that says that. Now, as to the peak factors, because I think what I just talked about resolves the 10% issue. As to the peak factors, I do want to point out something to the court, which I had noticed last night when I was going back through, and I've read through this so many times that sometimes I forget the things I've even seen. But there's a sentence here at the very end of the first, or there's a phrase at the very end of the first sentence, and it says the following. It says, the volumetric rate that PD pays will be based on each master meter volume reading at the delivery points. What that means is that their volumetric rate is going to be based upon their own usage, not based upon system-wide usage. The master meter volume readings at the delivery points, those delivery points, as defined in the contract, I can show your honor, are defined in the Exhibit B. This is a map of PDE. These are the delivery points. You can see that. There are 4 master meter delivery points in Exhibit C to the contract. What this means, and earlier in the contract, it defined the initial water improvements that would be built to connect our system to their system, and states that these delivery points are going to be more particularly described in Exhibit B. So these delivery points, these master meters, are the meters that measure their water usage when we deliver water to them at those delivery points. Meaning, coming back up to the sentence at the very beginning, the district shall pay an amount equal to the PSB's then current rates for wholesale service, the PSB wholesale rates, with the volumetric rate based on each master meter volume reading at the delivery points. That is a definition that says that your rates were based on your usage, not somebody else's usage, not system-wide usage that we had to use for a period of time because there wasn't anything else at that juncture. So while PD was, when they first came along in 2003 was when the contract was signed. They didn't start accepting water until 2005, Your Honor. The first amendment took place in 2007. As we said before, they were still very much in an initial development period. They weren't ready to be put on their own peak rates. So they received these huge concessions, and now they're trying to turn around and protract that treatment for the rest of the contract and have their rates calculated in a way that nobody else has their rates calculated.
Mr. Weller,
Even
let me just stop you right there because I do want to hear Mr. Green. What is your response to that portion of 4.1 that references a volumetric rate based on each master meter volume reading at the delivery points?
Yes, so there are certainly aspects of the methodology that's set that would be measured based on the volumetric rate at that meter. And in fact, if you look down at the very next paragraph, it talks about the amount of water service actually delivered shall be equal to the amount as determined from the master meter reading data. And so that's not saying that ignore the methodology when it's saying something other than measuring at the meter. It's saying to the extent the methodology involves volumetric measurements, then you need to do it based on the master meter, not some other meter, not delivering from somewhere else or to somewhere else. So that's all it's saying. It's not, and remember, you have to harmonize it. You have to harmonize that provision. That Exhibit J is a set methodology. Exhibit J uses system-wide peaking data for its calculation. And so that provision that Mr. Weller's talking about now, and he's right, this is a new argument. I haven't heard it before, but that provision is talking about when you do have to measure at a meter in order to calculate the rates under the methodology, here's how you do it.
All right, go ahead, Mr. Weller.
Okay, thank you, Your Honor. I don't understand the counter argument there. I mean, there's no way to read this sentence that I just referenced, this phrase, by calculating their rates based upon system-wide information. And it's really common sense. I mean, if we're going to, we have a cost of service contract that says it all over the agreement that they would pay cost of service. That is the fundamental overarching goal. We cannot reach cost of service if we're using water usage data that is not this customer's own water usage data. Trying to calculate their rates based upon this proxy replacement data for the entire 60-year contract is completely the opposite of cost of service. So the contract contains specific statements about volumetric rates at the master meter being the basis of their rate. It has general terms that says cost of service. All of those things get to the same place, which is we are supposed to use your information, Mr. Customer, to charge your rates. Otherwise, you're going to inherently end up with the wrong, incorrect determinations of what the rates are. We can't calculate a correct rate for a customer using system-wide information. Period. We just can't. And I'll get to some of the other points, Your Honor. At the end of the day, if PDE is allowed to avoid these charges that basically every other inside city and every other wholesale customer pays, it will have one of two effects. It will either prevent the utility from having a sufficient amount of money to operate the system and maintain the system, the water system, in all the ways that it needs. Or alternatively, there's the possibility that out of necessity, that the rates for inside city customers may have to be increased somewhat to accommodate and subsidize the charges that PD is not paying. And that's what we're trying to avoid, is having to have less resources than necessary to maintain and operate the system, or from having to make decisions like that. The utility doesn't want to do anything like that. And like I said yesterday,
let me just stop you real quick. And I may have missed this. We might have discussed it yesterday, and I just don't remember. What was the trigger to go back and look, for example, at, what's the 2021 trigger again, when we go back and start looking at PDE?
There was a review of the overall wholesale rates. It was not intended to be specific to PDE. The first change, Your Honor, was there was an overall review by EP Water Administration and EP Water's rate consultants, which just did a review of what those rates were. And there was an examination, and the utility noticed that the 10% has not been assessed to those wholesale customers. And I think there was more awareness on the utility about the specific requirements in the bond documents for who the 10% has to be assessed to, and the monies that have to be paid to the city out of that. And the utility realized that it needed, under the bond obligations, to be assessed to everybody. And they went ahead and made that adjustment across the wholesale class. Secondly, the timing of the situation with PDE was they looked at PDE's peak rates and determined that PDE's peak rates had leveled off at a point where it seemed like their individual peak rates were the best measure of cost of service at that juncture. Your Honor, you asked me a question yesterday that I think it's a fair question. You said, well, why didn't they have a set term in the contract that they would switch over to individual peak rates after 10 years? And I think the reason is when the contract is signed in 2003, there's so many unknowns at that point. The parties don't know how long it's going to take for this party for PDE to move to and have its own stabilized peak data. So let's just say, using the concept of 10 years. So if it was signed in 2003, if we had moved them over to their own peak information in 2013, their peak rate was still $2.49, and the system-wide was $1.92. So what that would have meant was their rates would have immediately jumped 30% higher, and they would have hit the roof. It was not until 2016-17 when their peak rates started to consistently level off in comparison to system-wide. And after a couple of years of this, seeing that they seem to have stabilized, the utility makes a decision, says they have reached a point where their data is leveled off. They're no longer in this development period, and their data is a reliable measure. Instead of penalizing them during these early years, it's clear to see why this didn't happen early on, because during construction periods, they're using more water. The water use is concentrated in certain months, and their peak rates end up being very erratic and much different than their normal state. So the utility doesn't do this with anybody. They don't put anybody on their own individual peak rates during these development periods. They wait until the customer is leveled off, and the other thing about this peak rate argument, in the rate setting world, the concept that we would continue to use system-wide data for a customer after their own specific peak is available is a wild concept. Neither of the rate consultants discussed this as anything remotely normal. So the fact that PD has pushed back against this is just they're just trying to do anything they can to avoid the rates going up. We are harmonizing all contract points, and we submit to the court that PDE is actually not, because they're reading and they're interpreting things in a way that does not match up with the language. The last point about the legal issues, I don't want to belabor this, but PDE's position before the court literally is the law does not apply to us. This 791-026, there is not a single court in Texas that has ever interpreted that as something that overrides other provisions of law. That case law just does not exist. No court has ever said that. The Interlocal Cooperation Act is a way for local governmental entities to enter into contracts with each other. It applies to school districts, community college districts, counties, cities, and there are a variety of statutes that relate to the Interlocal Cooperation Act, but that is a general statute that applies to the provision of water facilities. And what we have here is a far more specific statute in the water code that applies specifically to wholesale customers, which says that you have to treat them on the same basis, calculate the rates on the same basis, unless they are differently situated. And it's some legitimate way that justifies lower rates. So PDE's suggestion is that you have this generalized statute in the Interlocal Cooperation Act. You got this note at the end, which no court has ever interpreted the way they're saying it should be. And then on the other hand, we have a specific statute that applies specifically to wholesale customers that says that it does not apply to contracts that is signed before the statute, but any contract signed after it is subject to it. So PDE would have its very generalized statement operate to control over specific law in the water code and specific law in the government code that deals specifically with water rate setting. And there's just no support for the idea that two parties can contract around the law. That would lead to absurd results. That would mean all the two parties would have to do is slap a label onto a contract saying it's a 791-026 contract, and now none of these other laws apply to us. Now, one last point about that. To the extent there's a reference in the contract to 791-026, that is because in some measure, the contract did relate to the construction of facilities that we've talked about to deliver water to these delivery points. But that is the reason that there was a reference in there. There is no court that has ever said that 791-026G operates to eliminate any of the other water rate standards that apply to, water quality, water rate setting. That all just does not exist. So, Your Honor, I just wanted to make those points. We really think that whether you apply the contract as written or you look at the law in an objective way and look at PD's circumstances, that they are required to make both these payments. They're trying to branch off and get their own rates, which is not supported in the contract. They're trying to pay rates below cost of service, which is not supported in the contract. They receive this treatment regarding their peak rates for a period of time, but everybody pays their own customer specific peak in El Paso. We talked about the uniformity of the rates yesterday. I can go back through that, but we have 220,000 inside city customers and 7 wholesale customers outside the city. Every one of those that buys water pays the 10%, and you've got one that doesn't pay peak rates. And we described the circumstances for that, which are much different than PD's.
All right. Mr. Green, did you have something else?
Yeah, I'll wrap up. Mr. Weller, can you stop sharing your screen, please?
Sure.
Yes, thank you, Your Honor. Just real quick in response to that point that they won't be able to pay their bills somehow if we get charged based on what we actually contracted for. Remember, they spent 18 years not charging us those ways, and they have managed to survive. In fact, during those 18 years, every single wholesale purchaser, according to Mr. Weller, didn't pay the 10%. So it's just a fallacy that if Your Honor rules in favor of Paseo, that EP Water will be harmed in any way. What actually happened in 2021 is they looked at their rates, they got a rate consultant, and they found a way to increase people's rates. I understand that as the seller, they would like to charge higher rates, but one of the things that our summary judgment evidence shows is they didn't bother to look at our contract when they did that. Had they looked at our contract, they couldn't have started charging us the 10%, taken away that cost exclusion, and changed up the way they did the peaking. So, Your Honor, we would respectfully request that you grant the plaintiff's motion for summary judgment, deny the defendants. This is a question of law. There's no reason to continue to go forward with trial or further discovery. Let's look at the contract, enter summary judgment based on its provisions. We get the same methodology through the life of the contract. Thank you, Your Honor.
Right. Mr. Weller, is yours basically the opposite? I don't want to
Yes, Your Honor.
oversimplify, but go ahead, Mr. Weller.
Yes, Your Honor. I mean, we're asking for our motion to be granted. We think it's the correct application of the contract and the law. I want to give a moment to Patricia Borshaw. Patricia, is there anything you want to add to the court? And Patricia's in-house counsel for the utilities, so she lives this with our employees every day. Patricia, is there anything you'd like to add to the court for the court's consideration?
And Your Honor, yes, may I address the court?
Yes, ma'am.
I basically would like to reiterate what Mr. Weller has already argued yesterday and today in looking at the contract in its entirety. And that's how it should be applied, looking at the contract as a whole. What Mr. Green is trying to do and how Mr. Green is reading the contract is he's using tunnel vision. He wants the court, and he's only focusing on this Exhibit J. And Exhibit J is what's written in stone, and Exhibit J is what should be followed. And that is absolutely incorrect. You have to look at the contract in its entirety. Mr. Green's also just picking sentences from sections 4.2 and 4.1 and only using the ones that he feels are only adequate for his position. But if the court reads the contract in its entirety, the language is there. And the language and the interpretation is there. And it will show that El Paso Water did not breach this contract. Furthermore, Your Honor, El Paso Water is a governmental utility, and it's a nonprofit governmental utility that cannot seek funds in any other way. So if PDE doesn't want to pay the 10% like the other wholesale customers, then what's going to end up happening, as Mr. Weller had stated earlier, is it's going to be on the El Paso Water ratepayers that have to subsidize and hold over and pay for what PDE doesn't want to pay. And so I just would like to ask this court to find in favor of El Paso Water and to grant El Paso Water's summary judgment.
Thank you, Ms. Borshaw. Mr. Weller, I guess that's everything. I didn't hear from Mr. Davis, but that's okay. I'm not asking you to unmute or anything, Mr. Davis. Just figured I'd give you a shot. Let me tell you, I had reviewed probably fairly quickly the entirety of the contract, but because you all have done such a thorough job, not only in your pleading, but in your arguments yesterday and today, of course, there's no way I would rely on that, not on my notes. I am going to be very thorough in reviewing everything from yesterday and today. I have this fancy YouTube recording, so anticipate I'm just going to rewatch and go back and compare my notes and reread things. Now, even with that said, you can expect a ruling fairly quickly because now that I don't think we're in trial tomorrow, I have some time. And so I'm going to be able to sit and do that. Let me think. There was something else. No, I think I'm good. I think I'm good. You're going to have that ruling well ahead of the next setting, which is the April 3rd final civil pretrial. Okay. I don't recall. I don't know if you all submitted proposed orders, especially with the last kind of supplements, responses and replies, but wouldn't hurt to send something in Word over from each of you, so I can look at those as well. Okay. All right. Thank you very, very much for your time and your efforts. I really appreciate how well you all briefed this and presented it to the court. Thank you for that.
Thank you again, Your Honor.
Of course. Is there anything else?
Nothing from the plaintiff. Thank you, Your Honor.
No, have